of my peers here. Dan, are you on the line?
I'm here.
Dan wanted to make an announcement to the group, and then we'll start getting into the content.
Yeah, thanks, Katie. Just want to take a quick moment. So my name's Dan. I'm the Director of Community Relations for the Board of Directors with NHRC. And this month, obviously 2020 has been a little different with being able to volunteer our time. We're doing group sessions in the community. So for this month, being Breast Cancer Awareness Month, we have opened a donation line on the NHRC website, so mynhrc.org, where you or anybody you know could go and donate to the American Cancer Society for the remainder of this month. And then NHRC is being awesome in matching donations up to $500. So your donations will be doubled for the rest of the month. So that's our community relations effort for this month, and would appreciate your support.
Thanks, Dan. All right, we have our special guest today, John Stanis, and he is coming to talk to us about legal updates. It's been a while since the NHRC has done any updates on legal, so we're excited to have John. John, welcome.
Thank you, appreciate that. It's nice to be back, even virtually. It's nice to see faces and talk to different people. I miss getting out. For those of you who weren't at the update that I presented, was it a year ago, 2 years ago? I forget. My name is John Stanis. I'm an attorney with Masuda Fanai, Eifert & Mitchell. We have offices in downtown Chicago, Schaumburg, and Los Angeles, although I actually live in Florida. I currently live in St. Augustine, Florida, having previously lived in Orlando and Miami. I am originally from the Chicago area, though, so I do know what that's like very well. Spent my first 40-something years up there. Today, although it's titled as Employment Issues in 2020 and Beyond, naturally the main focus is going to be on COVID-related stuff because that's what everybody's dealing with right now. We're getting constant questions on COVID, a variety of things, everything from how to deal with the Families First Coronavirus Response Act, what do you do with quarantining, what do you do with employees who don't feel safe, what about the layoffs that we thought were going to be 6 months layoffs and turns out maybe they're going a bit longer. And then at the end, I threw in a topic that's been coming up lately. It's unrelated to COVID. It's more relating to social media, ransom demands, and politically and socially active employees and some of the issues that can come up there. If nothing else, I figured we could stir up some trouble and maybe even get an actual Zoom argument going. I think that might be a little bit of fun. So that's what we're going to talk about. I understand that you all can go ahead and unmute yourself as you wish. I believe you're all muted now. If you want to pop up and ask a question, I'm perfectly fine with that. Otherwise, I think you can shoot questions to either Denise or to Katie, and they will go ahead and read them to me at the end. I'm going to try to leave at least a half an hour-ish at the end so that we can have as many questions as possible. But as I say, if you want to ask them going along the way, that is perfectly fine. I'm trying to talk fast because this was a program that I'd done a few weeks back and it was in a 1 hour program. When I heard that I have a half an hour, I figured I better get caffeinated and kind of ramp up the speed. So here we go. Workplace safety. This is a fairly typical scenario that folks are dealing with. I'd say I get calls on, we have an employee who's tested positive, or we have an employee who has positive symptoms at least every other day, and it's been that way for the past month and a half. So in this scenario, you've got a service tech who goes out, deals with machinery, and he tells the boss on Friday, I'm not feeling so well. He's got a fever. He's going to go in and get a test. You know, he's then diagnosed as having COVID-19, being positive. And then the question is, well, what do you do about communications? And one of the first questions is, what do you communicate? What do you say to Joe? What do you ask from Joe? Probably the primary first thing you want to talk about is, in effect, contact tracing. Okay, Joe, when did you first feel these symptoms? And then you want to go back, according to CDC recommendations, at least 48 hours before that and say, who work-wise have you had contact with in person? Now, the CDC's definition of what is considered a close contact is anywhere where you're within 6 feet for 15 minutes or more And it's supposed to be without a mask, but I would say even with a mask, because of course there are different ways you can have the virus transmitted to you. Many people aren't wearing eyewear protection. So you talk to Joe and say, who have you had contact with? Now, in this case, Joe's going to say, well, I was at a customer on the 14th and 15th, which is more than 48 hours before he first came down with symptoms, assuming he first presented with symptoms on Friday. He was then at the office on the 16th. So it is perfectly acceptable to say to Joe, you know, when did you first start feeling symptoms? Ordinarily, that's a medical inquiry. But the EEOC has said that, you know, in terms of restrictions on the medical inquiries under the Americans with Disabilities Act, that you can go ahead and ask questions like these because they're job related and they're consistent with business necessity, meaning you have a valid reason for asking them, and what you're trying to do is protect the people in your workplace. Probably have an obligation under OSHA to do contact tracing, so then the next question is, what do you say to other people? Do you tell the coworkers, for example? And what do you tell them? One of the key things is, as with any personal health information, even if it's not covered by HIPAA, you don't disclose to anybody the name of the person or people who have tested positive. In many workplaces, they already know. You don't need to tell them. They've already told their coworkers. Some people, when they test positive, they send out a blast like, woohoo, I got it. I'm in the club now. Generally, you know, you don't have to tell people. You can't tell people. That goes for coworkers. That goes for customers, anyone else. What you can and should say is look at the people who are, hi,
Good,
Mike.
how are you?
You look at the people who are, who have been in close contact, and depending on how your workplace is laid out, you might want to talk to even people who might have had, you know, incidental contact, maybe through common areas. So it depends on the workplace. In some cases, you look at a unit and say to the people in this unit, you have been exposed to someone who has recently tested positive for COVID-19. We want you to be aware of that. Sometimes then the question is, what do you do with those people? If they're non-symptomatic, do you require all of them to then quarantine? And we're talking about quarantine in just a little bit, but again, that may be a case-by-case situation. If you have a small office and you quarantine everyone who's had contact with the person who tested positive, you may have nobody left at work, which might be appropriate in some circumstances. In this case, though, you're going to say, okay, on the 16th, Joe, who did you have contact with? Who did you talk to in person? Where were you in the building? And then for the customer, you don't have an obligation to tell the customer because that contact was outside of the 48-hour period of contagiousness. In other words, 48 hours before he became symptomatic. But as a matter of business relationships, you might want to at least let them know that they were exposed to an employee who tested positive a few days later. Because if they do hear about it later, and they probably will, you don't want to have to deal with the ramifications of them feeling left out or feeling like you're hiding something from them. It's just good customer relationships. So,
John, we have a question that came in. If someone tests positive in our office, is it safe to come into the office when they are not there?
In other words, when that person's not there? Well, that's one of the questions that comes up regularly is we've had somebody who's tested positive. They've been in the office, you know, regularly for the past several days. What are we required to do? Well, as a matter of OSHA, you are required to implement the sanitization procedures. Most of our clients, what they're doing is if you can segregate a particular unit and say, you know, this employee was only here, say back in the warehouse, they'll close that for a day, bring in outside crews, have it completely sanitized. If nothing else, it helps to reassure the employees that they're working in a safe environment. Because otherwise, if you don't do that and you just say, all right, everybody grab some of the wipes that we have handy, I'm not sure that most people feel real comfortable with that's sufficient. In other cases, we've had clients where they've looked at it and said, we're shutting down the entire facility and we're going to clean. Now that really depends. Is your facility an office? Is it an office plus warehouse? Is it manufacturing? and how segregated are people within the workplace. So it's kind of case by case, but you're going to want to do beyond the ordinary cleaning before returning people to the same work area. In our office's case, we have a written policy that says if any of our offices have a positive, the entire office will be closed and sanitized before anyone is allowed back in. So related to that, I guess, is workplace safety and employee concerns. We've got another scenario listed here where you've got a manager who's saying, hey, or rather a service tech says, I'm concerned about travel. I don't want to go out of state to travel. And so then he's allowed to go ahead and perform phone duty, work in the office for a while, but a customer needs service out on a site. What do you do with that? One of the key issues and focuses for these concerns are, what are the actual duties? It's almost like an ADA accommodation analysis. You want to look and say, what are the essential duties of the position? What can be done remotely? The guidances in most states issued by their governors is, to the extent that people can work remotely, please continue to allow them to do so. If the job simply cannot be done remotely, you can do some splitting of time. What can be done remotely should be, what can't be, you have to be in the office. Travel is similar to that in the sense that if it's an essential part of the employee's duties and it truly cannot be dealt with otherwise, like servicing a machine, you can say to the employee, we're going to do everything we can to make sure this is safe. So you can look at other options. It doesn't necessarily mean you have to fly out there. It's safer to drive than to fly. You can make arrangements for people to try and stay overnight in particular places that may be safer. Give them some control over the environment. One of the issues that'll come up is, what if they do have an underlying health condition? Under the ADA, you still have an obligation to provide a reasonable accommodation, but keep in mind, even under the ADA, the employer's obligation is to provide a reasonable accommodation that will allow the employee to perform the essential duties of the job. It's not always the requested accommodation. So you're looking and saying, what accommodation is possible? Not everyone with an underlying health condition necessarily has a disability, so you shouldn't just leap to that conclusion either. It's all part of having a dialogue. So the main thing is talk to the employee, try to understand their concerns, try to accommodate where possible. Even if legally you can take a hard line, we all know that if you do that too often, you're going to end up sued one way or another. You're going to affect employee morale, retention, and all of that. One of the baseline questions we get is, well, if the employee absolutely refuses to travel or refuses to come into the office, can we terminate them? Again, if the essential duties truly require them to be there to do that, to perform that function, then the company can go ahead and discipline the person. Whether it rises to level of termination may depend on, as with other decisions, how are you treating similarly situated people? What is the employee's performance and disciplinary history? What is the rule that you want to set for your company?
John,
so,
what if
yes.
a person has a medical reason not to wear the mask?
All of the guidelines say that if a person has a medical reason to not wear a mask or to not wear other PPE, then they're not required to do so. At the same time, because the company has an obligation to keep other employees safe and provide a safe workplace under the OSHA requirements, you'd have to look and say, okay, if you're not able to wear a mask, we need to otherwise screen you off from other employees. You can't be using, say, the lunchroom. You can't use the bathroom. And how functional is that? An inability to use the bathroom presents its own health risk. So you cannot require the wearing of a mask, but you also have to look and say, if that's the accommodation you need, can we actually accommodate that and still have a safe workplace? So that's an excellent question. You can explore a little bit. Some people will say, I can't wear a mask because I've got a health condition. You are allowed to say, what health condition is that? That's part of the ADA accommodation. It's not like, some people early on in the pandemic were carrying around little ADA cards that they got from the internet, sort of like get out a mask free cards. And it says under the ADA, you can't force me to wear a mask and you can't ask why. That's not true in the employment context. You do get to ask why. What is your medical condition, and to consider the different ways of accommodating it. So it's a good question. Comes up fairly regularly, particularly in certain states. A little less in Illinois. Workplace safety, and that's what a lot of this is about. I mean, there's two main focuses: is keeping people safe and getting the job done. I think everybody understands by now that if we all totally lock down all the time, we'll have a nice mass unemployment that will go on for a very good long time. That is preferable, of course, to some of the more serious downsides of COVID-19. So most companies are engaging in some type of screening, and it's not only for employees, it can be for visitors, if you're even allowing visitors in. In the case of our firm, we are not permitting visitors to our offices. Clients cannot come in. Nobody but the photocopy repair guy gets to come in. And even in that case, there has to be a 24-hour reservation. I can't go to the office right now. I can't just show up. We have reservations and slots. So when people come in, you have different options. Many companies are doing temperature checks. That may be using a temperature gun. It's probably the wrong word for it. I guess just a temperature scanner, sorry. And taking the person's temperature. It may also be asking questions. And ordinarily, of course, under the ADA, you're not allowed to make medical inquiries. But again, unless they're job related and consistent with business necessity. The EOC has said that so far as the CDC says it's okay, keep doing it. Keep in mind, though, that at some point they might change that, so you have to pay attention. It is, in a sense, an exception to the ADA's ban on medical inquiries. What you are allowed to ask is, are you feeling well today? Do you have a temperature? Have you been in any COVID hotspots? Have you been exposed to anyone who is symptomatic? Are you symptomatic? You can walk through all of the ever-increasing list of symptoms. Is anyone in your household symptomatic? Have they been traveling? You can go through lots of different questions, and they can be done by sitting down with them or asking them to fill out a form. None of them are mandatory. I think if a company said, we're not going to ask any questions and we're just going to check temperature screening, that might pass. And that's frankly what a lot of public entry places are doing. For example, you go to Disney World, they're not asking questions, they're just checking your temperature. There are some issues. If you take too long in this process, you may have an issue as to whether or not you're required to compensate non-exempt employees for the time spent. If it's just minimal, you wouldn't have to. But basically, you're asking questions that ordinarily you wouldn't be, and that's for as long as the pandemic lasts. What type of testing is permitted? As I mentioned, you can do temperature testing. You can also ask them to self-report. In our firm's case, employees are required to self-report, answering the quiz or the questionnaire and reporting on their temperature before they even leave home for work. Ideally, you don't want them there in the first place if they're going to fail. And so that's what we've done. You can, depending on the circumstances or the company's arrangement, what you do. For example, if you're in healthcare, you've got a different situation, but you can do testing for the live virus. Of course, the problem with that is it takes a while before you're going to get reports back. Even the rapid testing with its high rate of false positive and false negatives, many companies aren't using it. They don't want to incur the expense. What you cannot test for are antibodies. You can test for the live virus. You can test for temperature. You can ask about conditions. You cannot test for the antibodies because all that tells you is the person previously had it. The fact that they previously had it is not really related to whether they expose or there's a risk for someone else. So some of the questions are, all right, we've got an employee who has tested positive. What do we do with them? I'm sorry, I'll get to that in a second. If I'm not mistaken, I believe that's the next slide. So one of the questions is, how frequently can you test? Most companies will do it when people arrive into work. and they'll do it then. Others do it in the morning and in the afternoon. I've had several cases where employees pass the screening in the morning only to become violently ill in the afternoon. And in one client's case, they had several people become ill in their warehouse the same day, the same afternoon, and they all passed the screening in the morning. What do you do if people object or even refuse to take the tests? Have their temperature taken, maybe they consider it an infringement on their privacy. Then I think you talk to them and say, okay, here's why we're doing it. Communicate with them that what you're trying to do is keep the workplace safe for everybody, and coach them into agreeing to do it. At the end of the day, it's you need to do this. This is a mandatory requirement for everybody. There should be no exceptions for any position. And then you say, you have to do it if you want to keep working here. If you don't want to keep working here, well, then you don't have to take the test. So that's basically the bottom line is testing has to be across the board, and it really does need to be mandatory. You don't want to do it necessarily position by position.
John, we had another question come in.
Sure.
If an employee is tested positive and is working remotely, may I require him to retest after his isolation and send me his negative test results before we allow him to return to work?
Mm-hmm. And I'm assuming this is an employee who is working remotely because they tested positively, as opposed to they're already working remotely. Because in terms of the testing, if an employee is working remotely and that's consistently what they're doing, you're not allowed to ask these questions or require the reporting of temperatures, because they're not posing a risk to anyone else within the workplace. It's no longer consistent with business necessity. I assume the question deals with somebody who works in the office, got sick, and they're working remotely while they're recovering or recuperating. There are different ways that an employee can be cleared to return to work. One is based on symptoms and others based on testing. And let me go through them. Symptoms. Basically, if you've got an employee who has become symptomatic and tested positive, that employee is required to be quarantined by CDC recommendations for 10 days from the first date they started experiencing symptoms. Their period in which they are able to communicate the virus to other people is typically from 2 days before the onset of symptoms to 10 days afterwards. That's why you'll see recently with President Trump, his doctors were saying 10 days after he had the onset of symptoms, he is being cleared to return to his regular activities. So that's one standard. The other is if you have an employee who has been exposed to someone who is positive, and they don't go get a test, so you don't know whether they're positive or negative, whether they have it. What is recommended is that they quarantine for 14 days from the date of exposure. Now that might sound longer than the person with 10 days, but that's because what they're essentially doing is they're building in 2 to 3 days of contagiousness. So you've got basically 14 days from exposure is roughly equivalent to 10 days from the onset of symptoms, because most people are presenting with symptoms within 48 hours after exposure. So they're roughly the same, but that it gives you the protection against people who are asymptomatic but may be positive and contagious. The other way of doing it is if an employee has tested positive, and they're out, the question is, what tests can you require before they return? If you want to go a testing route, you can require the employee to have 2 negative tests at least 24 hours apart before they return. And one thing I want to clarify when I said before the employee, if they become symptomatic, they need to be out 10 days from the onset of symptoms. That assumes that at that 10th day, that they are symptom-free, that they're no longer symptomatic, have not been symptomatic for at least 24 hours without the aid of medication. In other words, you talk about people being fever-free for 24 hours. You can't be taking medications that suppress the fever on your 10th day and then come to work on the 11th. So you can go with either a symptomatic approach, they have to be symptom-free, or you can require 2 negative tests at least 24 hours apart. The downside with the testing is it takes, in some places, 2 to 3 days just to get the test back. But the company does have the option of saying that's what we would like you to do. So mandatory quarantines, and it kind of relates to travel. This is a scenario that's come up again multiple times, particularly in the summertime when people were itching to get out. They figure they're working from home anyhow, might as well go somewhere. If I'm working from anywhere, I could be in sunny Florida. Why not? And it is sunny. It's a beautiful day today, just gorgeous. So, an employee may say, all right, we're going on vacation. Just want to let you know, I'll send you a postcard if such things still exist. And then so the questions come up of, well, can we just say no? You can't go there. And how do we distinguish between one location and another? The company, if it can implement and devise a consistent policy and practice that limits where people can go, can say to employees, as a matter of policy, we're telling you you can't go there, but it's not really that you can't go there, so you can't come back here. Kind of like the opposite of the bars at the end of the day. You don't have to go home, but you can't stay here. It's kind of like that for the work environment. So what you can say is, all right, the hard part there is, how do you, as a company, designate or determine what are the so-called COVID hotspots? I think many people still have it in their mind that Florida is a top-to-bottom raging COVID hotspot, and the reality is it isn't. Miami-Dade County, down Lauderdale and Miami, they're still fairly hot. The rest of the state things are fairly quiet, other than a couple of spots over the Panhandle. But as an employer, you can't really get that granular, and you don't want to be making the call on your own. So depending on where you're at, you can look at the state, county, or city websites. Their departments of health typically are going to have data where they consider to be the hotspots and where they think if people go there, they should be quarantined upon returning. Because most companies aren't going to say you can't go there on vacation, or in a scenario, what if it was a funeral? In Mason City, Iowa, which is a very small rural place, which happens to have a fairly high COVID rate right now. You want to rely on what the public health departments are saying, the places that they've identified. Keep in mind that that can change. And typically what you're going to say to the employee is not that you can't go, but that you have to quarantine when you return. In other words, you have to work from home if your job permits working from home. Can you require employees who have traveled out of state to be tested before returning to work as an alternative to quarantining? Yes, you can, but keep in mind you shouldn't have them tested immediately upon return. What if they caught the COVID-19 on their flight back? They'll test negative for the first 2 or 3 days because they haven't built up the antibodies to the virus. And the amount of the viral load in the body won't be sufficient for testing typically. So yes, testing as an alternative to mandatory quarantining is a possibility, but you have to keep in mind the timing of that. They might be required to be out a few days after the test is conducted before it comes back, and you may even delay the actual testing. So, sorry, I need to take a breath. The main point between Florida and Mason City is don't operate based on assumptions or on population size. You need to look at the county health and state health departments to find out where they're identifying. How long should the person be required to quarantine? If they're asymptomatic or have no symptoms and they haven't tested positive, typically you're again looking at the 14 days just in case. The big question that keeps coming up is, what if the employee can't do the job remotely? Are they entitled to be paid? And that's what most employers are pushing for. And generally the answer is no. Because in effect, then employees would be able to extend their paid vacation another 2 weeks by just going to a hotspot. Make sure you go to a place that'll require quarantine and you could stay home without working for 2 weeks paid. That's kind of a bad motivation. You're motivating in the wrong direction. So the answer there, if they truly cannot work remotely, will be no, you're not getting paid. If they can work remotely, then by all means, let them continue and do that. There's no reason not to. Working from home with little people around. This is one of the big issues that numerous clients have dealt with. Our firm struggles with it, is many people have school-age children. Typically we're talking about younger ones. The high school ones can kind of fend for themselves. But if you've got a kid who's junior high or younger, they might not be in school full time. They might not be in school at all physical school. They might be doing virtual schooling. And so some of the questions are employees entitled to stay home under the Families First Coronavirus Response Act as part of the emergency FMLA expansion? Again, assuming that nobody's symptomatic and that they haven't been ordered to quarantine, you're basically dealing with the EFMLA. The answer is going to depend on mainly, why is the employee needed to provide the child care? Is there no one else who is suitable to care for the child? So then you get to actually ask that question. So, all right, why you? Keep in mind, don't engage in sex discrimination while you're doing that. If you're going to ask that question, ask it of everybody. Don't just ask the men or don't just ask the women. But you do get to explore on an individualized assessment kind of basis why this employee is necessary if there are alternatives. Like in this scenario, you've got a father and mother who are no longer married, they share custody, and they're having an alternating schedule that's also part virtual, part in person. The Department of Labor has said that employers are not required to allow intermittent EFMLA time off for childcare. However, they later modified that to say that, well, in this kind of a split scenario where it's 3 days virtual and 2 days in person, we don't consider that to be intermittent. We think those 3 days that are virtual, those are proper uses of the expanded FMLA time off. And therefore that can be required even without the employer's consent. Are they entitled to pay? Not as a general matter, like unless they qualify for the FMLA, the paid sick leave. Excuse me, the FMLA side of things. In other words, if the employee's used up their 12 weeks of FMLA time already, then they're not entitled to any pay. If they're able to work remotely, they're not entitled to pay. So it depends on whether their school is closed in the sense of not being available to that child on that day. Is there anyone else who's suitable to take care of the kids? Are they able to work? One of the questions that comes up is, well, what if you've got this kind of split schedule and the employee just doesn't want to keep coming into work 2 days a week and they'd rather just work virtually? Those other 2 days are not considered EFMLA because school is open and they don't have to be there to care for their child. The same situation applies if a parent simply decides they don't want to expose their child to the risks of going to school, again, unless there's someone in the household who has an enhanced or increased health risk from it. But otherwise, if what you have is people without additional health risks and they just simply don't want to run that risk of sending the kid to school, that's not considered a qualifying reason under the expanded FMLA. So one of the related questions is, people may only be having virtual school 9 to 3. And you say, well, why can't you work after that? You technically could say, we'd like you to then work from 4 p.m. to 11 p.m. That's a bad idea, because then what you're getting is somebody who's exhausted from trying to keep their kids sitting down at a computer, and you expect them to do a full day's work after that. First off, they're not going to be communicating with people in prime time. They're still going to have that child at home. And while technically you might be able to say, here's part of the requirements, we'd like you to work the time when your kids are not in school, the reality is they're still taking care of the kids on those days, so don't do it. You're buying yourself trouble by doing that. One of the related things to be aware of is how do you compensate people who are non-exempt when they're working remotely? The employer still has the obligation of the FLSA to record hours or to make sure hours are tracked. However, the DOL has said you do not have to go to extraordinary lengths to do that. If you have a reasonable reporting system, it's up to the employees to use that. And even though the employer could do some sort of electronic monitoring of when people are working, they're not required to do that. They're not required to go back and screen emails. If employees have a way of reporting hours worked and they don't do it, then that's on them, is what the DOL has said. How are we doing on questions?
No new questions unless there's anybody that wants to speak up and ask you some.
Okay. Well, then I'll just keep it going. WARN and the pandemic. WARN, of course, is the Worker Adjustment Retraining Notification Act. There are, as I'm sure you all know, there is a federal statute, and most of the states have their own state statute. The Illinois statute is very similar to the federal one. The main distinction is that there are different qualifying numbers. So for example, the federal statute, the employer has to have at least 100 employees. The Illinois statute is 75. Then when you look at what are triggering events that require the 60-day notice to the employees or to the state office, you've got mass layoffs, you've got plant closings, you've got just general employment loss. A mass layoff is under federal law, it's 33% of the employees at a particular work site, but at least 50 employees, or just a layoff of more than 500 people. The state one is essentially half of that. It's 33% and at least 25 employees at a site, or a layoff of 250 employees. Plant closing, and this is where you sometimes get issues. A plant closing is a permanent or temporary shutdown of a site or a particular operating unit. And then the issue is, what's temporary? Because a lot of people laid people off back in March or April, even May, and then they say, well, we thought it was temporary. Now, there is an exception. Temporary as defined under the federal WARN and Illinois state WARN is not exceeding 6 months. But there are times where you are into it and you realize it's going to go beyond the 6 months. Most companies wouldn't know that going back to the spring, how long this was going to last. I don't think anybody really knew. If they did, they're very special. So companies that might not have given a WARN notice to employees in the spring might still be obligated to do that if they are now on notice that it's likely to continue beyond the 6 months. There's an exception for, sudden, dramatic, unexpected developments, conditions beyond the employer's control. But I don't think anyone could say that that COVID is sneaking up on you lately. So if you have a sense that you've got layoffs that are out there that may be subject to WARN and they're going to go beyond 6 months, you need to look at providing notices now when you're aware of that change in condition. As I say, I don't think anyone can call the pandemic unforeseeable anymore. In fact, how long it lasts is unforeseeable, but that's why you're seeing a lot of the airlines and a lot of travel related things like Disney World, they're giving out notices because they realize, okay, this is going to go on and now we need to be laying people off. The other thing that's driving a lot of layoffs lately is, depending on the industry, the PPP loans came with restrictions that you cannot lay people off through the end of September, and we're beyond September. So that's why you're seeing a lot of layoffs in the news lately. So here is a totally different topic. That's not how they say it in Monty Python. Now for something totally different. This is something that's come up, I would say probably 3 times since the start of August. It may be because it's an election year, but my sense is it may be something broader. Typically, the way this comes in is that we get a call saying, hey, we got an email from somebody we don't know. It's either an individual or it's some public interest organization sending us a copy of a post that one of our employees put on Facebook or some other blog or some social media site. And we find it offensive. We wanted to give you an opportunity to disavow this person, or we're going to expose your company as being, that you employ people of this type or ilk, as my grandmother used to say. And that raises a number of different questions. This similar sort of scenario can come about not necessarily from social media activities, but simply political activities. People attending protests or supporting a particular cause or candidate, and others either inside or outside of the company may be upset about it. And so sometimes the question is, what can we do when our employees engage in either social media activities or political activities that through no desire of the companies are starting to impact the company? One of the questions there is, of course, to confirm that the employees are engaging the activity off premises and off hours. can certainly regulate what people are doing when they're supposed to be working for you or using your equipment. But related to that is you want to look and say, is the speech that they're engaged in somehow work related, or is it purely political or purely social? Work related, of course, would be things focused on your company, your industry, your employees, working conditions. Related to that is if you see that you're getting a complaint that so-and-so is complaining about supervisors. I think many of us know that the NLRB and the National Labor Relations Act gives employees the right to engage in concerted activity for mutual aid or protection, which means that one employee ranting probably has no protection. Two employees getting together to bitch about the boss may well be protected under the NLRA. Then the question there is, okay, what are the employees doing online, or what are they doing in, say, protests, for example? If they're out at a union protest, that may well be protected activity. So you have to look, is it work related, or is it just purely something other? Sometimes the question we'll get from people is, well, what about free speech? We got the First Amendment, and I know my rights. It's almost inevitable when somebody says, I know my rights, that they're not a lawyer and they don't actually know their rights. Because one of the key things of the First Amendment is it applies only to public employers. It applies to the government. It does not apply to purely private employers. So you have to look at the nature of your organization and say, are we an arm of the government? Are we financially supported and regulated by the government? So sometimes that gets extended in certain arguments where if all your funding comes from the government, say you're not for profit, and instead of being a 501c3 or a 170A, I think is the tax code reference there. In other words, you're mainly supported by the government. It's not so much the government funding alone, but if you're government funded and government regulated to a degree that you may be considered controlled by the government, the First Amendment might apply, but for 99% of y'all, that's not going to be relevant. And so that's, it's important to keep in mind that people should feel free to speak and have their own lives and their own opinions, but that's also can be balanced against what the company needs. I saw an article the other day said, in Illinois, can you fire Nazis? And I'm thinking, okay, it sounds like something from the Blues Brothers 30, 40 years ago, and the answer is generally, can you fire employees for having what most people would consider reprehensible and offensive opinions and expressing them? The answer is qualified yes, generally. The difficulty is there is an Illinois statute that says that employers are not allowed to retaliate against employees for voting or not voting, or attempt to coerce how they vote or don't vote. That is different from political speech. It's focused on the act of voting. And a company can say that somebody's opinions as expressed online or in person are offensive enough that we don't want to be involved with them. It's similar to if a person commits a reprehensible crime, you can disassociate from them. Not so much because they got arrested, that would be improper, that would be an improper act, but because of the underlying conduct. So the company can take steps to protect its reputation and morale. As to whether you respond to whoever initiated the contact and made in effect a ransom demand, you will do this, or here's what we're going to do to you. You'd have to look at the scenario and situation, and I think exercise your own judgment as for what's best for your company. Not so much giving into the demand, but you might agree with what they're thinking. Also depends on what your company does for, what is its essential purpose. If it's to provide, say, vaccines, and you're a pharmaceutical company selling vaccines, and you've got an employee who is strongly against vaccines and is publicly out there speaking against them, at some point, even if they don't identify themselves as an employee of the company, you may be able to say, that's nice, all well and good, have a nice life, but you don't work here anymore. There are specific state laws that can affect some of this. So you have, for example, California, I'm sure it won't surprise you, has somewhat different laws on the issue than others. and they will restrict your ability to terminate employees for their beliefs or for free speech. Illinois has the Illinois Right to Privacy in the Workplace Act, but what that actually protects is the lawful use of lawful products. Mainly that was intended to protect people who smoke and drink from being terminated for smoking and drinking. And that it got kind of tangled up with the legal use of marijuana earlier this year, and they kind of untangled that a little bit. But the Illinois Right to Privacy Workplace Act does not extend to political activities, social media activities, and simply doesn't relate to that. So for the most part, you're going to look at where the employee is. There are other states, of course, New York and some others that have specific laws, but in Illinois, generally looking at, is it somehow work-related? Is it protected speech under the NLRA, the National Labor Relations Act? Is this something that's likely to cause problems with morale within the company? And if so, then you can go ahead and consider what action, if any, you want to take. It doesn't have to be what was demanded. You may just say to the employee, would you mind cooling it? However, keep in mind, there is also an Illinois statute that says that employers cannot require employees to, as part of the Right to Privacy Work Act, you can't require them to allow the employer access to their social media accounts, to open pages for them to look at it, to share their passwords or their username, to friend an employer. You cannot require any of that. So typically, this is going to be something that is brought to your attention by another employee or someone outside the company. And if you want to start arguments, this is a great topic to throw out at a lunch table when lunch tables exist once again. How are we doing on time here? Got a little bit more. I'm going to throw in a bonus topic, something that has come up repeatedly in the last 4 weeks. And probably many of you have heard about this. The Illinois Department of Employment Security is having massive fraud problems. And we keep getting contacts from clients saying, we just received a form from IDES saying that the president of our company was laid off and he's entitled to unemployment benefits. In fact, he already got the debit card at his house. The IDES has said that in this year alone, they've had over 155,000 cases of fraudulent applications for benefits. What people are doing, and I'm not sure who's doing this, I think it's somebody within IDES, they're submitting fraudulent applications online. They qualify for the benefits. Then right before the debit card is mailed out, they're mailed out within 7 days of approval, they go ahead and do a change of address so that the card gets sent to them. They're apparently not very good at it because most of the times the clients are reporting that the employees are saying, I just got this debit card from IDES. What am I supposed to do with it? And so I'm not sure how much money they're making off of it, but it must be enough to keep doing it. The IDES does have a hotline for reporting it. Good luck getting through. It's not easy to get in touch with them. There's an FBI hotline for reporting, same thing. They won't do anything with it either. Instead, what you need to do are 3 things. One is send a memo out to your employees, maybe even before it comes up, saying we're aware that there are these that there's a active amount of fraud on unemployment claims. If you receive anything from the IDES indicating that an application has been made in your name, bring it to our attention immediately. If you receive a debit card, don't use it. So that's one, is to communicate with employees. The other is, of course, yes, go ahead and report it to IDES, particularly on the 4 more employers are responding and saying, this is not a proper claim. This employee still works with us, has not been laid off. Don't call us the chargeable employer. And then, assuming the IDES still won't get it right, watch your taxes and watch the reporting to make sure they're not taking your money out anyhow or dinging you. The way this can hit employees is, even if they don't use the card, that income is being reported to the IRS under the employee's name. So they're going to have attributed income on income they never had. So it's turning into quite a mess. IDES is not doing much that we can tell from the outside to solve the problem. Most of the data that they have, including the reported earnings data, appears to be accurate, which is why initially many clients thought it was a hack on their side, because they look and say, yep, that's our guy and that's what he makes. Because I've seen it across so many different employers, I think it's a problem with the IDES side. So that's something you need to be aware of. If it hasn't hit you yet, it probably will soon. So, any other questions, Katie? How are we doing?
There's no other questions that came through. If anybody wants to unmute and ask John questions directly, please feel free to do so.
Hey, John.
Yes, sir.
Hey, how are you? Nice, very good presentation. Thank you. You're welcome. Real quick, going back to the social media portion, and you mentioned about you can't require employees to open up their social media accounts and give access. I thought I heard you say something else and I missed it. I was curious, was it like if we asked during an interview, hey, can you share your post with us?
Yeah.
Like to prove that you didn't do this. Someone saying, I didn't do that, I'm being hacked or whatever. Is that fine, or should we stay away from that?
There's almost two scenarios there. One is if it's an interview, you can't say to an applicant, tell me what your Facebook name is, or open it up online. Let me take a look and see who you've befriended and that kind of stuff. You're not able to do that. If you're in a scenario where somebody has brought something to the company's attention, and typically they're sharing screenshots of it, and there are actually activists out there who are, I don't know that there's a word for it yet. I've been trying to develop a new word, but what they're doing is they're looking at people's activities online, doing background research on them, and in a sense, outing them to their employer. When they do that, they're typically sending in screenshots. And sometimes they're not doing it anonymously. They're saying, here's who we are. We're not hiding. This is your employee Bill the Nazi, or whatever they want to call him. It's usually something not nice. In that scenario, you can talk to the employee and say, this is what was sent to us, and can you share anything with us in terms of information? Not so much show us your Facebook page or show us your entries to prove you didn't do this, but give them an opportunity to respond and explain. Most of the time when it's been that type of somewhat out there ranting, it's not been a great surprise to the employers, because they look and say, well, yeah, that really doesn't shock us. So, a conversation with the employee is fine. Asking them to reveal information from their accounts is not, unless they want to do so. They can. Did that answer your question, Sean?
Yep, thanks. As a follow-up, how about like this canceling and whatnot people are trying to do? Like this activist, for instance, they've gone back to someone's past, back when Twitter or IG started in 2010 or something, and they found something that they wrote. Now it's 2020, and for Jiminy Crickets, the person is like a simpler employee and everything. There's no evidence, and now they're like, look at this.
Yeah. And that's harder because, people have different levels of sophistication, and I don't know that not many people understood what they said online 15, 20 years ago will be there forever. The younger generation, they understand that. They almost anticipate that. Their entire lives is electronic and shared and unerasable, excuse me. I would be inclined to, as with many things, look at the situation, look at their duties, look at the possible impact, and then say, okay, let's allow a little grace for people to have grown, to have changed, and to learn from the opportunity. You don't necessarily, I wouldn't overreact, but it all depends on the circumstances. You find out that 20 years ago the person was a child molester. People may say, I don't care if it's 20 years ago, it's as good as yesterday. I don't want them sitting next to me. And then you may have to deal with that. So it depends on the circumstances, but there's no reason to overly judge people based on what they did a decade or two ago.
Okay, thank you.
Generally. Okay.
Are there any other questions before we wrap up? We got time for one more.
If not, I do want to thank you all. It's been good to be here. I'm sorry that I had to talk so fast. I'll try and do something a little simpler the next time around, and I certainly hope that'll be in person, because getting out and meeting people is what's fun.
John, can't thank you enough for your time today. Wealth
Absolutely.
of knowledge, extremely helpful. If you guys want to reach out to him, you can see his contact information is at the bottom of the screen. Also, feel free to connect with him on LinkedIn. The other piece I want to make you guys aware of is some of the roundtables that are going to be the next couple months. So in November, we're going to be having the Mom Project and Exxon RMS speaking to us about working parents and how we can support them as they're helping their kids with e-learning. And then in December, we're going to be talking about mental health and how to support your employees going through difficult times during the holidays. Thank you for your time. Appreciate it.
Can I say a few things, Katie?
Go right ahead, Phil.
Right, thank you. And one other, thank you, John. Great presentation. Really liked how you shared scenarios with questions. And I'm sure a lot of us on the phone have experienced some of these scenarios or will experience some of these scenarios. So thank you for that. And I'm jealous that you're in Florida and we're in Chicago. That's the great thing about COVID is that people can work anywhere, right, these days. And
the state's not closed here. Come on down. Plenty of room.